Appeals Division 1 is now in session.
Good morning. Please be seated. Good morning. Today is February 20th, 2025. First, I want to take a moment to recognize that we have students here from Verrado High School observing argument. We're happy to have you here and hope it inspires you as you look towards your future. This is the time set for oral argument in our case number CAIC240034, Douglas versus Montecito Safety National. Out of respect for counsel and to avoid any embarrassment for anyone in attendance in the courtroom, please make sure your cell phone is on silent. Each side is allocated 20 minutes for oral argument, although you are not required to use all of your time. If petitioner wishes to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium. The clock on the podium reflects your total remaining minutes. Please keep in mind that we have read the briefs, studied the record, and discussed the case in conference. So please keep that in mind as you present your case. These proceedings are being live streamed and will be available after argument on the court's website. Counsel, you may proceed.
Your Honors, thank you for granting oral argument in this case. My name is Eric Auerkamp, and I represent the injured worker in a workers' compensation case. That's Ms. Sheila Douglas, who's in the front row behind me. This is a case involving the calculation of the average monthly wage for an injured worker. The average monthly wage is a critical number. That is the multiplier of that injured worker's benefits, both temporary and permanent. So it affects their compensation the rest of their life. So it's a critical number that is fairly and accurately calculated. In any industrial average monthly wage calculation case, the most important thing is to start off with the correct definition of what the average monthly wage represents. And to do that, we go to the seminal Arizona Supreme Court case, Lowry versus Industrial Commission.
Wouldn't we actually go first to the statute?
I'm going to do that because the court interprets the statute a little bit, and the court is going to reference it, but you're correct. That's ARS 23-1041. And I'll get there in just a second, as the court did. So the court first started out, and they made
My point was just that if you look at the statutory definition, and it clearly applies, we wouldn't need to go to any further interpretation, correct?
Almost. Let me tell you what the court did here.
I think I might know what the court did because we have read the briefs, but
Okay.
My concern is just as the starting point. Do we start at the statute?
We can start at the statute.
Okay, could you explain to me why, in applying the language of the statute, the ALJ was incorrect?
Okay. The statute, the operative terms in the statute is that the employee's average monthly wage is at the time of injury. So that's all the statute sets forth, and that's the first.
I thought the statute defined average monthly wage.
Correct. It's the average monthly wage at the time of injury, and that's what the statute focuses in on. And that's the first thing the Lowry court looked at. It needs to be at the time of injury, not prior to the injury at some point. The court then says, we look to the goals of the Act and the evils it's designed to remedy for the foundation of our decision. Because what the Supreme Court's going to do there is they said, we're going to get to the bottom of what is the Act really intending to do in interpreting this statute. And the court sets the second pillar, and they state, when they define the average monthly wage, the court says the average monthly wage, quote, should realistically reflect a claimant's actual monthly earning capacity.
Okay, but capacity is not listed in the statute, correct?
You are correct.
Because the statute defines average monthly wage as average wage paid during and over the month in which the employee is injured.
That's subparagraph 2, that's B, where it talks about the 30-day presumption is what we refer to it as. And generally, you can look at the earnings the 30 days before the accident and take that as a presumption. The Lowry court recognized the gap that's there, that doesn't always hold true. The purpose of the average monthly wage, as the Supreme Court defines it, is earning capacity at the time of injury. If those two foundational pillars are in place, all the Arizona cases will fall in line. Then the court went further and said, we disavow all bright line rules. In fact, even if subparagraph B, that 30-day presumptive, defeats the capacity at the time of injury, then you can overcome the presumption, which we do all the time in work comp, because, and the court said no bright line rule, and that presumption can be set aside because it just waits for the factual situation that comes up when there's a vacation or there's something in that 30 days. And the court says that doesn't fairly represent earning capacity at the time of injury.
So, counsel, it sounds like what you're saying is that the legislature did impose a bright line rule or rules here, but our Supreme Court, of course, we're bound by the rulings of the Supreme Court, said something a little differently. Is that what you're saying?
No, what the Supreme Court said is that Part B, it was a bright line rule that's only a presumption. And what the court said is, if that presumption is going to defeat the purpose of the average monthly wage being earning capacity on the date of injury, then you can push the presumption aside. You've overcome the presumption right there. And so the presumption is there, it's in the statute, we do apply it. And in a lot of typical cases, it's a fair presumption. Look at their earnings for the last 30 days, that's their earning capacity. But we get a whole lot of cases, like this case, where that's not the case. In the court, and that's the reason the Lowry court came out and said, we are disavowing all bright line rules. Because if you try to apply a bright line rule, you try to pick one component here, that's one of the evils that they're trying to overcome. In the Lowry case itself and then the Swift Transportation case are a good example where you get opposite results, but they applied the principles. So for example, in the Lowry case, that was an injured worker who was a inspector. He had a high wage as an inspector. He had a second job as a volunteer fireman. 4 days before the industrial injury, his job as an inspector is terminated. So the only employment he's holding on the date of the injury itself is the volunteer fireman job. And the insurance company at that point said, well, that's his earning capacity. Those are the only actual wages earned. And actual wages is not the definition. And the court points that out. It's earning capacity at the time of injury. And so what they said was, we have evidence here.
I'm sorry, I'm going to go back to what Judge McMurdy asked. I mean, the statute says wages paid. It doesn't say earning capacity. And I understand what you're saying, that Lowry says that, we're disavowing bright line rules. But how can we just disavow what the statute says?
It says it's the wages, and I guess wages is a vague term, but the Supreme Court said, well, the purpose of it is what's earning capacity. And so there's a lot of cases here you're going to see where they're going to step out. They want to know the capacity of the person at the time of injury.
See, I'm not sure you answered the question, Judge Foster's question. It says paid. I don't think that's not ambiguous to me. The wages that were actually paid.
I understand your argument there.
I'm not making an argument.
And if you go to the Lowry case, they didn't limit the wages paid as of the date of the injury there. They said the purpose is capacity at the time of injury. This person has a history of working these two jobs. You can include both of them in calculating the average monthly wage. We can then switch to the Swift transportation case. That's another case where it seems on its face to have an opposite result. You have somebody who is a truck driver trainee. He's making $250 a week. He then becomes a full-time truck driver, and almost immediately, shortly thereafter, he gets in an accident. Now, as a full-time truck driver, he's making $645 a week. And in that case, the court initially stepped up in 2006 and said, well, wait a minute. In Lowry, they said we can go get those old wages. So let's go pull all these wages in and average them together, which lowered his wage down dramatically. And the court said no. From Lowry, what's the earning capacity at the time of injury? At the time of injury, he's a full-time truck driver. And his capacity to earn is as of that day. And therefore, you're not going to pull in the prior lower wages of when he was a trainee. It's what's his capacity at the time of injury. And they set forth many arguments to support this. The Supreme Court says this figure is going to be a point of comparison against his future earnings. In the future, his earnings is going to be as someone who's a full-time truck driver. And therefore, you need to have apples to apples. What's his capacity at the time of injury? And then go forward, comparing against that. Not as a trainee, and then comparing him with a full truck driver later.
As a point of clarification, you said the Supreme Court, but I thought in Swift it was a Court of Appeals decision.
Correct. The principles that they were applying were from Lowry, the Supreme Court case. The Swift Transportation was the Court of Appeals, which I thought very insightfully looked at Lowry and said, it's not just, the court wasn't saying you can just go pull in prior wages. There's no bright line rule to go do that. The court said, what's earning capacity on the date of injury, which is what Lowry stands for, and they said, we're going to apply that here, and they got to the right result. So you go to the facts of the present case with Ms. Douglas. Ms. Douglas had worked for 10 years as an LPN. She decided she wanted to increase her earning capacity and her marketability, and so she went back to school. And for over a year, she's working part-time as an LPN and going to school. She completes her schooling, she gets her license as an RN, she goes back to the employer and says, I want to be hired in as a new RN in a new position. They agreed, they gave her new wages as an RN, they then gave her hours to start working, and I think she started about 30 hours and she was going to ramp up. But in this case, even the actual earnings you're referencing, the actual wages paid at 30 hours a week puts her over the statutory max. So as of the date she got hurt, she was a working RN making over the statutory max in a new position with new credentials. What the ALJ did in this case at the hearing level, they just went and said, well, look at Lowry, you can go back and just pull in all these wages, let's average them all together, and they averaged her well below $2,000. Well, it's absurd to think that as a registered nurse, she can't make over $2,000 a month. She was making over that at the time of this injury and would have continued. And there's a lot of language in the Lowry case. It says the purpose of the act is to compensate an employee for wages he would have earned without his injury. In other words, what would she have continued to have done? She would have earned the wages as a RN. Also, what is the practice, the standard in workers' comp? We can go to the Arizona Work Comp Handbook. It says, the average monthly wage calculation is intended to reflect the applicant's monthly earning capacity, not merely actual earnings. And then it says, at the time of the accident. The handbook did a very good job, I think, of synthesizing all the case law in Arizona down to the court's interpretation of the statute, how it's applied, and the purpose of the act. and said we look at the capacity at the time of injury. And that's where you calculate the wage. You can go to all these cases, and they can appear to have opposite results because of bright line rules. But if you look at those two principles, if you say, what's the capacity at the time of injury, the right result comes out, and all the cases start to fall in line.
Counsel, if we were to agree with you, it's my view that we have two options. We either affirm the award or we set it aside. If we set it aside, or if you assume you're the ALJ for a minute, how do you resolve this? Or what happens on remand when it goes back to the
Absolutely.
commission?
That's an easy one. That's where the judge simply says, okay, we had the earnings as an RN established, and there's a lot of evidence and testimony about she was working full-time and would continue to do so. There was some argument as speculations to how many hours she would have worked. There's no question, though, historically, she was at 30 hours a week before the injury, only ramping up, both her testimony and the employer's. But even at the 30 hours, she's at a statutory max. It's an easy one to remand back and say, you need to look at what her earning capacity was on the date of injury pursuant to Lowry, and there you have the wages. She's over the statutory max. It needs to be reset at that. The evidence is in. You simply don't go back on a bright line rule and say, let's pull in a prior year of earnings when they were part-time as a student. That's just not fair to this applicant and for her future earning capacity.
So applying the statute, counsel, are you just saying that you should only apply those 30 hours that she worked, or are you saying that we should look at the entire month, or the ALJ should look at the entire month prior to the injury?
She only worked for 2 weeks before the injury. So to pull in the prior 2 weeks, in other words, to make it a full month, you'd be pulling in a time period where she's not working at all. And you'd be averaging in, so it'd come out about half of what her earning capacity is. And there's other case law in Arizona where you can exclude any time period that's not representative of what's, as of the date of injury and what's intended.
But even if we accept your position of the 30 hours, that was within those 30 days, right?
Yes.
Thank you.
Thank you. I'll reserve the rest of my time. Thank you.
Counsel?
Good morning, Your Honors, and may it please the Court. My name is Trevor Hansen, and I'm here representing the respondent's employer and insurance carrier. The petitioner has put forward what is essentially an issue of judicial discretion. There was some talk about how there is a presumptive 30-day wage base when setting the average monthly wage. Multiple Supreme and Appeals Court decisions have stated that this is a weak presumption, that the ALJ has discretion to move past to overcome where there's evidence of variable earnings, of variable hours worked, and other factors. And in fact,
I don't find any cases that support a 12-month average that would be deemed under the facts of this case. What's your best case to say, oh, sure, we can look at an entire 12 months to determine what our Supreme Court has said is the earning capacity at the time of injury?
It's in published opinions, especially common.
Give me one.
Sure. In Wozniak versus Industrial Commission, it comes up a lot in seasonal employee cases where...
Was she a seasonal employee?
I can't recall exactly whether or not was in Wozniak they were.
Was this case? Was she?
No.
You're saying let's impose a seasonal rationale to somebody who was not a seasonal. Well, that's not how it works. I mean, you presented and said, let's go for a 12-month average when she had been working only as an RN for the 2 weeks prior to the... That's what her job was, an RN. And she had only been working as an RN for the 2 weeks prior to the injury, correct?
Well, I'm not sure that the record supports that. She received her licensure as an RN in September of 2021.
When was she hired as an RN?
I'm not exactly sure that's in the record. clerical change from part-time to full-time was in the record October 30th of 2021.
Okay, so at best, we would look at only the time period in which, at best, we would only look at the time period where she was an RN.
Possibly, but the records also show that she worked more hours in the 2 weeks before October 30th than she did in the 2 weeks after October 30th. And so there wasn't a sudden shift in hours at that point. And coming back to the 12-month period.
Well, yeah, I was going to say, how do you expand, where if we're looking at an RN period, clear back to a period of time when she was not working as an RN?
Well, she stated herself at hearing that the duties she was doing were essentially the same. Being an RN meant that she had the ability to administer a few additional types of IV medications. But as far as the day-to-day work, she testified that they were similar. And so there's not a big change there necessarily that I think warrants calling this an abuse of discretion.
So if an injured nurse, well, generic nurse, comes in and testifies that says, yeah, my duties are the same whether I was an RN or an LN, which would we use?
As a matter of law, I'm not sure that you have to choose one or the other.
I'd say, well, what were you? Oh, I was an RN. Okay, that's what we would use. We wouldn't use the other category if she wasn't working in that capacity, would we? And why would we if we did?
I think there's a strong argument there, but at the same point, that's not what the petitioner is pushing for here. They're seeking to take only the prior 2 weeks of work where she was working full-time hours, rather than looking back to, you could go back to September where she received her licensure, you could go back to October where she was switched to nominally full-time status but continued to work part-time hours.
So let me give you a different hypothetical. You have a student, they're in school to become a nurse, they're not working, they start working, work for 2 weeks, and then get injured. What wage would we use then?
You would use the wages that she was earning before she was injured. I believe Morse versus Industrial Commission is fairly on point in that regard.
So we wouldn't go back to all the time that she was a student and account for the time that she was a student and not working.
I think that's a finding of fact, whether or not being a student reduced the number of hours that she was able to work. In Morse, you have a student.
We'll make it even. I'm going to jump because it's a
Okay.
very good hypothetical. And that is, we have a law student. They cannot practice as a lawyer because they haven't passed the bar and all that other good stuff. And finally, they pass the bar, but they have earned nothing until they pass the bar and start a job. And they work for 2 weeks and they're injured on the job. Are you telling me we would look at the 12-month average, which means we would take their 2-week provision and average it out based on no work in that capacity?
Well, and correct me if I misunderstood what you're asking. I think in that case, SWIFT probably does come closer to applying, because in SWIFT the focus is on the claimant earning provisional wages during a training period. And the court said in such a case where the claimant's actual earnings are not representative of their actual labor, but are rather a matter of employer policy, then a more prospective looking at their wages for setting the average monthly wage is appropriate.
Don't you believe the correct answer would be you would only look at the 2 weeks that they were actually employed as a lawyer?
I think that comes much closer to looking at, I believe it's Section B of the statute, where there's the specific cutout for employees who are not employed for a continuous 30 days prior to sustaining the industrial injury, which isn't the case here. Even as an RN, the petitioner was employed for well more than 30 days prior to sustaining the injury. And so it's important to look at what those wages actually were, rather than looking forward to what those wages and hours might have been in the future. Going back, you asked briefly about the 12-month period That has been affirmed a number of times in memorandum decisions. You had Perkins versus Industrial Commission, May 3rd, 2022, and Coburn versus Industrial Commission, August 8th, 2023. Both of those are appellate decisions affirming an ALJ use of a 365-day wage base.
And are they similar in the sense that was there a promotional period at the end, or is it you're back to your seasonal worker scenario?
I don't believe it's either one of them. You have a school security guard who does less work during the summer, but still does do some work over the summer and more work during the school year, which is not entirely dissimilar. The circumstances of the reduced work are different, of course, but there is a period of less work and a period of more work, and in that case, the ALJ was affirmed in averaging out that whole year's period.
So, Counsel, if we believe the ALJ erred and we set the award aside, what do you think should happen on remand?
I think the ALJ still has the discretion to apply an expanded wage base. I don't think this is a case where the ALJ is required to use the presumptive 30 days because the petitioner's earnings did vary significantly from week to week, from month to month. When looking back to what should be done, you have to look at where did the judge cross the line? At what point, looking back, did they go too far? Are they allowed to look 3 months back? Are they allowed to go 6 months back? If a year is too far, at what point?
How about if you say she couldn't look past the RN designation?
Well, I don't know if that date is in the record. And so we'd have to,
The question
yeah.
is on remand.
Sure, and that's a good point. We would have further hearings and then that would come to light. And again, to that point, what makes the RN decision? Sure.
It would be when she was hired when she was promoted to being an RN. Because that's what we're talking about, right?
In essence, I think that puts too much emphasis on there being a difference between her work as an LN and her work, or LPN and her work as an RN. In her words, the jobs were essentially the same. The pay increase was, she said, between $2 or $3, which comes out to between 6 and 9%. It's not a monumental change that I think makes it legal error to go back further than that, where the number of hours that the petitioner was willing or able to work had a greater impact on her earnings.
Counsel, under the statute 231041, are we under A in this case, or are we under B? So A is sort of the, shall receive the compensation fixed in this chapter on the basis of the employee's average monthly wage at the time of injury, and B, which, refers to, non-continuous employment. Which section is this case under appropriately?
I think it's definitively A. I don't think there's any question that the petitioner was continuously employed for a period of 30 days prior to the injury, no matter what designation or qualifications you look at. She was listed as full-time. She was still working at part-time hours during that period. And so I think this soundly falls under A, where we're looking at the wages actually earned rather than the claimant's earning capacity in a prospective manner as considered by Section B.
Thank you.
Coming back to SWIFT, I think SWIFT is particularly inapplicable to this case because the claimant in SWIFT was working for provisional wages. He was still doing the job of a full-time truck driver, but he wasn't.
An LN is doing the same thing as an LN is doing the same thing as an RN, right?
Yeah, and yes, and the petitioner was earning the wages of an LPN or an RN. She wasn't earning a provisional wage.
There was a provisional employee, and then he got promoted, and he was a regular employee, but he's doing the exact same job.
Right, and his reduced earnings in the provisional period was a matter of policy by the employer. He wasn't being paid
Isn't it a policy of this employer to pay LNs less than RNs?
Perhaps it is, but I don't think it's analogous to a training wage where they're being paid below their worth, is the sort of language used in Swift and then again in Morse. If I may, in Morse, the Court of Appeals clarified Swift, stating that it's widely recognized that apprentices, students, and other inexperienced workers often receive relatively meager compensation that is not an accurate reflection of what they will be expected to earn once they reach majority or finish their training period. That's not the petitioner's case here. She was working as much as she was able or chose to as an RN, as an LPN. She wasn't in a provisional training period. She had been with her employer for 11 years. And so the earnings she was making, she wasn't expecting to graduate to a different earning level in the future. The reason she
was an LN and she expected to be hired as an RN and she was expected to get a pay boost.
And I believe those earnings are reflected in the evidence, and the ALJ has the discretion to interpret those earnings as they see appropriate, most appropriate. The claimant's earnings as an RN were factored into the calculation of the average monthly wage in this case. The reason for the increased earnings in the 2 weeks prior to the industrial injury in this case was the result of the petitioner working more hours rather than the applicant receiving a wage boost for graduating from some provisional status. Coming back to your question earlier, Judge Brown, about what would happen on remand, I think that Elko Veterinary Supply versus Industrial Commission is illustrative of this sort of case, which I interpret as a garden variety average monthly wage case. There are some facts that perhaps push the bounds of what is acceptable. But in veterinary supply, the ICA calculated the monthly wage based on the claimant's earnings over a period from April through November. The root of the dispute was that the claimant's earnings varied due to variable commissions. They made a substantial portion of their earnings based on commission, and as they gained more experience, their commissions increased because they got better at their job.
Counsel, and correct me if I'm wrong, I thought the testimony in this case was from the employer that all of their RNs worked a minimum of 32 hours a week, and most worked overtime. Most or all worked overtime. You agree with me on that?
The testimony is certainly that that's what would be expected, but if you look at the actual wage data that's in the record, the petitioner didn't work more than 30 hours per week, even as a full-time employee, until the 2 weeks prior to the injury. I believe that payroll data is on page 80 of the hearing record.
My point being that unlike the commission base where we don't know what the commissions would be and we would need to look back to see what an average of commissions would be, we know in this case what the hourly rate was, and we know from the testimony in the record that the employer would expect her to work a minimum of 32 hours with additional overtime.
While that may have been the expectation, I don't think that the ALJ is required to make that conclusion that that is what would happen based on
Was there any other testimony that would contradict that testimemy?
The applicant's testimony that she didn't work full-time hours while being listed as a full-time employee.
I thought her testimony was, I'm going to be a full-time employee and I'm going to work overtime.
Yeah, yes, and that's the...
She said, this is what I'm going to do, and the employer said, that's what we expect her to do. So the ALJ would have had to just make something up in whole cloth to come to a different conclusion.
If the ALJ were required to look prospectively, then yes, but the average monthly wage is determined retrospectively. It looks back at wages earned, not wages that will be earned.
How do you explain?
No, go ahead.
How do you explain Lowry's emphasis on earning capacity? What was her earning capacity? Was what? It was what she testified to, and what her boss essentially testified to. This is the range. This is what you're expected to do. Minimum of 32, could be up to 45, 50. How is that not the earning capacity?
I think where it's at odds with the actual facts on the ground, where the actual hours worked are incongruous with that hypothetical number of hours that she may be expected to work in the future. I believe that Floyd Hartshorn Plastering Company number 2 is particularly relevant to this issue. In that case, there's 2 Hartshorns, Hartshorn 1, Hartshorn 2. In that case, the claimant was injured 23 days after receiving a routine wage increase. And after being remanded, the ALJ expanded the prior 23-day earnings to a monthly total by speculating as to how many hours the respondent employee might have worked that month, and then multiplied that number of hours by the hourly rate. That award was set aside for extrapolating a hypothetical number of hours and earnings that the claimant might have earned in the future, but for the injury. Both of the Hartshorns emphasize that the emphasis is on what is earned, not what might be earned. And that's, I believe, consistent across all of the case history on this issue.
The statute uses the term month. What do you think that means? Does that mean the previous month, calendar month, or does it mean the previous 30 days?
I believe that's been interpreted to mean the prior 30 days. I believe that's what the courts have used to establish the prior 30 days presumption. I have 18 seconds left, so if any of you have any questions, I can get those in real quick. Otherwise, I will yield my time.
Thank you, Counsel.
Your Honors, you had some questions about the chronology of when she was hired as a nurse. She went, following her getting her RN certificate in September, she interviewed with the employer in October. At that interview, there were 2 deaths of the family imminent in November. Therefore, they agreed to hire her as a nurse in October.
An RN.
Sorry.
She was working as a nurse.
She had not worked as an RN yet.
Well,
Oh, LPN. Thank you for yes. As an RN, they agreed to bring her on as an RN with a start date in December after the 2 deaths. She then started in December, 2 weeks prior to her injury. Now, there's a lot of talk about how many hours. As a nurse, in the first 2 weeks, just working that ramp-up time, her wages for the 2 weeks was already $2,007
As an LN or?
as an RN,
The first 2 weeks
the first 2 weeks.
of December.
So the first time she ever worked as an RN, paid as an RN, was December.
First?
Yes, started in December 1st. She then starts working as a nurse. The first 2 weeks, she makes $2,792. That already is going to be over the statutory maximum of $5,000 on an average monthly wage. So going back to some of your original questions of starting with the statute, we don't have to step out of the statute on anything here. What's her earning capacity on the date of injury in subparagraph A? And the presumptive, we don't go the 30 days because there was no work in November. She wasn't working and didn't have an agreed start date until December. So the presumption isn't going to apply. But we have hard earnings that prove that she was over the statutory maximum if she never went above that minimum of 30 hours or 32 hours. Also, to say the jobs were essentially the same, not true. They had different pay rates. They had different hours. There is some overlap. For example, an RN and a doctor. There are a few tasks that they will overlap and both do. But the one can do more tasks. That's the reason they're paid more. That's the reason they get more hours, is because the registered nurse can do more. And therefore, she was paid more in a different position starting in December.
Counsel, I'm looking at page 80 of the record, which your colleague referenced. And I'm just wondering if you can clarify, because it says that for the period of 11/16/2021 to 11/30/2021, maybe I'm looking at the wrong thing, but it shows 37 hours, and then it says for December 1st, 2021 to December 15th, 2021, it shows 74.80. So you had just said that there were no hours worked in November. I just want to understand why that's different, if you know.
I don't know where those hours came from in November, but she started on and had her 2-week period as a registered nurse in that capacity in December. We have those two, we have that pay in evidence.
And then last question that I have is, you had referenced Section A of the statute, Section B previously. Which are we in, A or B?
We're in A.
Okay.
And that's the only part that talks about the date of injury. B is that 30-day presumptive. There's no presumptive here because we don't have the 30 days.
Well, I would actually just say the definition
Yes.
of monthly wage includes date of injury. So if we're using that term anywhere in the statute, it also includes that.
And we can even use that word wage. We can still apply it out of the statute because we're looking at actual wages. We're looking at her actual wages that there's no dispute, it's in evidence. Even the defense agreed this is her wage, $36 an hour as a registered nurse, and the hours are going to ramp up. And we have the pay stubs for the 2-week period as a registered nurse prior to the injury. So we have actual wages. Thank you.
Thank you both for your presentation today. We appreciate your briefing and your argument. We'll take this matter under advisement and issue a written decision in due course. Court is adjourned.